So reading Harrison, sign it, please. You know, I have a funny feeling that carpet cleaning is not going to make any progress tonight.
A funny feeling that who's looking to come?
Carpet cleaning, it's coming.
Oh, I forgot about that.
There goes Stain.
No, it's ridiculous. If they do their job.
Okay, I think we'll get started. It's 3:30, the appointed hour. Introduce myself. I'm Frank Duffy, Town Council, and with me is Pat Harris, who's the Associate Town Council. And we're going to put together this program this afternoon, perhaps about an hour, maybe a little less, on the open meeting law, which is a subject of importance to everybody who's on a board or committee in the town of Falmouth. This is a training session, and we're going to hit the highlights of the open meeting law. We're not going to go through the law paragraph by paragraph. We're not going to go through the regulations paragraph by paragraph. We're not going to go through the minutia of the law, but we're going to go through the highlights of the law and hope that it's our goal that you will have an appreciation of the open meeting law and how it applies to your board and your committee, and the general principles of compliance with the law. I will explain a little bit later how you get some more in-depth information if you want it, and certainly encourage you to get the in-depth information and look at it at your leisure. If anybody has any questions today, you can just raise your hand and we'll acknowledge you, but I would ask that the questions be kind of a general nature. If you are from a board or committee and you have a specific question, that is probably something you should take up with town council at an appropriate time, either at your meeting or in our office. Oftentimes, specific questions have specific nuances or fact situations that kind of get overlooked often in public, and we would like to get you the correct answer, and it may take a little bit longer to do it, so we would have asked that you do it that way. The open meeting law basically provides that meetings of public bodies be held in a situation where they are open to the public. Now, there was a significant revision to the open meeting law in 2009. It took effect July 1st, 2010. We have discussed these revisions to the open meeting law at other sessions here in Town Hall and with individual boards and committees. But nevertheless, it bears repeating. It's probably one of the subjects that you can not get too much of, considering that the policy of the board of the law is to have government be transparent and open to all. One of the principal changes to the open meeting law that took place in July of 2010 was that it shifted enforcement of the open meeting law from the local district attorneys to the Attorney General's office. And the Attorney General now has a division of open government, which is located at 1 Ashburton Place up in Boston, that is responsible for training, public awareness, investigation, and enforcement of the open meeting law. Over the past several years, we have been passing out a homemade document, which we prepared in my office, called a Review of the Open Meeting Law. And we're going to retire that. So if you have one of these old versions of the open meeting law prepared by my office, appropriately recycle it. What we are referring to today, and which I will discuss in a minute, is this new guide. It's called the Guide to the Open Meeting Law. It's published by the Attorney General. And rather than make copies for everybody here, I'm going to tell you where you can get your own. You should go to the Attorney General's website, which is www.mass.gov/AGO, that stands for Attorney General's Office, /open meeting, and you will find there connections to a lot of information. You will find connections to the law, to regulations, training materials, advisory opinions, and orders of the Attorney General, as well as this open meeting law guide. And I suggest that every board or committee in the town of Falmouth make a copy of it and have it available through the chairman or staff of your board or committee so that you can refer to it anytime you need to. So I guess we'll start by just briefly talking about what is a meeting. A meeting, and I'm going to read the definition to you twice because it's really worthy of your attention. A meeting is generally defined as a deliberation by a public body with respect to any matter within the body's jurisdiction. So the elements of a meeting are, you have to have a public body, there has to be some deliberation on a matter within the body's jurisdiction. So let's start out with what is a public body. A public body is any multi-member board, commission, committee, or subcommittee. I want to emphasize the word subcommittee. There's some misunderstanding out there about whether or not the open meeting law applies to subcommittees. It does, absolutely does. So it's a board, commission, committee, or subcommittee established to serve a public purpose. And it includes multi-member bodies that are created to render advice or make recommendations. Now, we have within Falmouth certain multi-membered bodies that we clearly understand are subject to the open meeting law, the Board of Selectmen, the School Committee, the Board of Appeals, a few others. But there are also some boards that don't really have any specific authority other than to make recommendations or to advise public officials. Just give you an example, the Solid Waste Advisory Committee is one. Then there are other advisory committees on such subjects as South Cape Beach and Main Street beautification and so forth. But they are subject to the open meeting law if they are created to serve a public purpose. Individual officers of the town, such as the fire chief, who's signing in now, are not considered public bodies for purposes of the open meeting law, nor are members of their staff. So public officers can meet with their staff without having to comply with the open meeting law, and furthermore, they can meet with each other without having to comply with the open meeting law, which applies only to multi-membered bodies. But there is an exception to that, and I just pointed out, I'm not going to dwell on it, but I don't know if we've actually ever had this in Falmouth, but perhaps we have. A body appointed by a public official solely for the purpose of advising on a decision that the public official could make himself is not a public body subject to the open meeting law. And within the training materials given to us by the Attorney General, they make this example. A school superintendent appoints a 4-member advisory body to assist her in nominating candidates for school principal. Well, under the law, the school superintendent can nominate the principal without a committee or an advisory body. So because the body doesn't have a specific public purpose, the public purpose rests in the official, then it's not subject to the open meeting law. If you ever have occasion to use one of these advisory bodies, you might want to check with our office to make sure you're complying with the open meeting law. Another component of a meeting is the concept of a deliberation. And a deliberation is an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. Just read it one more time. It's an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. So it can be oral, you can be talking to each other and have deliberation, you can be writing to each other and having a communication, deliberation, including electronic mail, and I think most of us communicate by electronic mail these days. And you must remember that electronic mail has a habit of spreading all over the place. The forward button, I guess, is very popular on most people's computer. It does not include agendas, scheduling information, or reports or documents that will be used to be discussed at a meeting. So the chairman of a board or the staff of a board can distribute agendas, scheduling or procedural information, or reports or documents to the other members without violating the open meeting law. That is not considered deliberation. But once you include within the material the opinion of one person, then you are getting very close. In fact, you are at the definition of deliberation now when you have opinion. So, for example, if the chairman of the board distributes an agenda and the agenda has on it a controversial item, say item number 2, and the chairman says, I hope you will back me up in defeating the second item on the agenda. That's a deliberation, even though it's one person speaking to others without a dialogue coming back. It's an opinion. It's the expression of an opinion. And the fact that there's no immediate dialogue does not take it out of the category of a deliberation, because, of course, the response may come later. So in your distribution of material to members of a board or committee, do not express opinion. The other thing that you need for a deliberation is a quorum of a public body. And here we get into an area that is, I think, kind of perilous. Let's say you have a small body of 3. Well, a quorum is 2, so that makes it very difficult for any 2 people to talk. But let's say we have a body of 5. And if 2 people are talking to each other, well, that's not a quorum, except that you never know how far these conversations are going to go. So I like to use this expression. If A talks to B, and B talks to C, and C talks to A, you now have 3 people involved, and you have a deliberation, even though when the conversation started between A and B, you never intended it to be a violation of the open meeting law or to be a deliberation. So the open meeting law looks at multiple communications among members of a public body, and if in the end a communication has spread amongst the quorum of a body, you have a deliberation and you have a potential violation of the open meeting law, even though you didn't intend to do it. So my suggestion is, when you are going to discuss the merits of a matter that's coming before your board or committee, do it at the open session. I know there's a temptation to do it privately sometimes, and you think you can do it by just sharing it with one member of the board or committee, but often it kind of leaks out. I guess the expression now is it kind of goes viral on the internet. Well, it can do the same thing in your board or committee. Yes?
I'm very unclear about this because, for example, if you have a topic, well, I'll pick something from our committee, but zero waste. And you're going to have a discussion of zero waste at your next meeting. And I find an article in a magazine or something that has a really good discussion of zero waste. I can't mail that by email to the committee,
Yes,
so they can have that information in their head?
Yes, you absolutely may. But the discussion on that magazine article will take place at the meeting. And when you mail it to the other members of the committee, do not give them your editorial take on the article.
I don't say, this is what I think.
Don't say, this is what I think, or this is a great article. Simply say, this is an article I would like to discuss at our next meeting. And then you have avoided a deliberation, and you have stayed within the permitted conduct, which is to distribute material for later discussion. Another concept of a meeting is what is within the jurisdiction of a public body. There's not really much information on this subject, but basically when a quorum of a public body makes a decision or a recommendation, that matter is considered to be within the jurisdiction of the public body. So if you're trending towards a decision or a recommendation on anything that's going to be done as a group or as a body, you have something that's considered to be within the jurisdiction of the body. There are a couple of situations where the open meeting law does not apply, and I'm going to talk about a few. One is the idea of an on-site inspection. Now, many boards and committees do not have on-site inspections. Generally, the land use bodies do. The Conservation Commission, I know, has on-site inspections. The Board of Appeals may, Planning Board may, although they have staff that can go out and do it. An on-site inspection, however, should be exactly what it says, an on-site inspection. It should be members of a board or committee going out to a site and taking a look and familiarizing themselves with what they see, and the discussion should take place later on back at the public meeting. Now, there is a tendency when you have on-site inspections, let's say you have a couple members of the Conservation Commission out at a particular site. The neighbors see you there. They want to take this as an opportunity to bend your ear on the subject. So they approach. Remember, this is not an open meeting. This is an on-site inspection. Resist and do not take testimony from neighbors or other witnesses at an on-site inspection. If they have something to say, you invite them to come back to the open session of the board or committee and make their comments or their discussions at the regular session or at the open meeting. That way, everybody gets the same information. The information can be put into the minutes of the meeting, and you have full compliance with the open meeting law. But you can get into very difficult situations on on-site inspections when you let neighbors or other people come up and point out things or talk to you. It's a violation of the law, should be avoided. Members of a public body may attend a conference or training programs or a social event without violating the open meeting law. However, the caveat, you do not deliberate. And by deliberate, that means you do not discuss any matter within the jurisdiction of the board that you're on. Members of a public body may attend the meeting of another public body. However, you must participate in the meeting of the host body and not deliberate among yourselves. There is a requirement, I think, if a quorum of a body is going to another body, they both have to post their open meeting.
If they're going to be deliberating, if it's a joint meeting.
All right. And I think it's a good idea that if you know in advance that a quorum of a body is going to attend another body's meeting, that you just post it anyways, just cover yourself. All right? So that takes us through the definition of meeting. Pat Harris will talk about some of the posting requirements, and then we'll talk about executive sessions and records later, okay?
Right. Except in the case of an emergency, the public body must always provide the public notice of their meetings. And those notices have to be 48 hours in advance, excluding Saturdays, Sundays, and holidays.
Could you speak into the microphone so it...
I apologize. Sure. Could the rest of you hear what I just said, or should just keep going? Okay. The municipality's public meeting notices must be filed with the town clerk at least 48 hours in advance of the public meeting. They should be filed with the clerk to give him adequate time to post the public notice. The public notice must be conspicuously visible to the public at all hours in or on the municipal building at which the clerk's office is located. Falmouth has a bulletin board at Town Hall that is in compliance with the open meeting law requirements. The open meeting law provides for alternative posting possibilities for different municipalities, but Falmouth is already in compliance with the open meeting law, so any additional notices that are required, would it be via the statutory requirements, for example, the Zoning Board of Appeal or the Conservation Commission, that's just an addition, and that would normally satisfy the open meeting law requirements, but in Falmouth, we do in fact post all notices of all public meetings out here on the bulletin board. If a municipality intends to use an alternative posting procedure, they need to get it approved by the Attorney General through the Division of Open Government. All public meetings are subject to state and federal laws requiring accessibility for persons with disabilities. That includes the Americans with Disabilities Act and the Federal Rehabilitation Act of 1973 and any state constitutional provisions. So all open meetings must be accessible to persons with disabilities and must, for example, be accessible by wheelchair without the need for special assistance. And the meetings must also be in a building which is open to the public. Most open meetings in Falmouth are in this building and are open to the public. However, it would be okay to have a open meeting at an alternative location, as long as it complied with the accessibility requirements. Open meetings also need to comply with sign language requirements of interpreters for the deaf or the hearing impaired, subject to reasonable notice in advance by a person requesting the same. All meeting notices must be written in legible, must be legible and easily understood format. They must contain the date, the time, the place of the meeting. It must also list the topics that, as of the time the notice is filed, the chair reasonably anticipates will be discussed at the meeting. The list of topics must be sufficiently specific to reasonably inform the public of issues to be discussed at the meeting. While not required by the open meeting law, the Attorney General's office is in favor and encourages public bodies to revise their lists if new subjects should come to the attention of the chair after the notice went out but prior to the meeting. Also, if a subject comes up at an open meeting that was not anticipated by the chair and was not included in the notice, the open meeting law does not prohibit discussion of that subject at the open meeting, but the Attorney General encourages boards or public bodies to delay discussion of that matter if it's something of high importance to the public in general, if it's a controversial matter, or just a matter that is of great interest to the public. It's not required, but it's encouraged. That is my limited introduction on the notice requirements.
Okay, thank you, Pat.
Yes.
Yeah.
I'm sorry?
You post your agenda
Yes.
48 hours in advance, and let's say the next day, you mentioned something else came up?
Yes.
That would amend that agenda. Do you have to then, can you still hold your meeting at the same?
Yes. The Attorney General doesn't require you to even revise it, but it encourages it. And again, that's to give as many people notice of what's going to be discussed in case they're interested in the subject matter. It's not required. The definition under the open meeting law is reasonably anticipated by the chair at the time the notice went out.
I think we have a question, well, two questions in the back. Mr. Porter?
Could you go over the part again about sign language for the deaf? Am I to understand that any public meeting must have somebody available, or is that just if someone's...
The question was, because I don't know if everybody could hear them, about sign language for the deaf.
All right. Yeah, it's not an ongoing requirement. There has to be reasonable notification to the chair that there is somebody with a hearing impaired or is deaf and requests it.
Mr. Gregg, you had a question?
Yes. It says members of a public body may attend a meeting of another public body provided they communicate only by open participation. However, they cannot deliberate at such gatherings. I don't understand that. We have a member who's on the Finance Committee and the Solid Waste Committee. Does that mean he can't vote or make decisions or what?
At whose meeting?
Is that what that means?
No, I don't think so.
That somebody in Falmouth can't be on two committees?
No, that's not what that means. That means if members of one committee attend a meeting of another committee, perhaps as observers, for example.
Oh, but not be a member?
Not be a member, not being a member. If you're a member of two committees, you can attend the meeting of both committees.
Okay.
And you don't have a violation of the open meeting law because each committee posts its own notice of its own meetings. That's why you don't have a violation. Okay? And I think one of the points that Pat made is that if you have an agenda and an item comes up, if it's all possible to defer the discussion of the item that comes up late to another meeting when you can post it and list it among the items to be discussed, that's what the Attorney General encourages you do. You'll probably find out that a lot of matters that come up at the last minute only come up at the last minute because someone forgot to to bring them up at the appropriate time. And they can usually wait to be discussed for another week unless there's something like a imminent snowstorm or blizzard or something. But generally speaking, if you can, wait to discuss a matter at a regular meeting that is noticed in accordance with the open meeting law. Now we want to go on to the issue of executive sessions. A couple of rules about executive sessions. You can only go into an executive session if you first convene a regular session, which means you have to go through all of the posting notice requirements that Pat just referred to. To go into an executive session, the chair of the board or committee must state the reason for the executive session. So, for example, the chairman will state that we're going into executive session to discuss strategy for negotiations with non-union personnel, or to discuss the deployment of security devices or something of that nature. And you should give as much information as you can about the purpose of the executive session without compromising or revealing any, or unnecessarily revealing any information that might properly be subject of the executive session. You must also state whether or not the public body will reconvene after the executive session. The reason for that is you have a room full of people who now suddenly must get up and leave, and they have to go outside, and you shut the door as they leave. They have to know whether they should stick around, and at some point they could come back into the room and observe a continued public session, or whether it's all over and they should just go home and forget about it. Finally, the decision to go into executive session must be made by roll call vote, which means the chairman will simply state the name of the person, and then that person will go aye or nay in response to the name, and that will be recorded in the minutes by roll call vote. While you're in executive session, and Pat will get to this in her remarks later, but you must keep accurate records of the executive session. All votes must be taken by roll call vote, and you must only discuss the matters for which the executive session was called. So if you're sitting in an executive session and something comes up that you didn't think about, you got to start all over again. Let's go through the purposes of executive session, and there are 10 specific purposes in the open meeting law for executive session. One is to discuss the reputation, character, physical condition, or mental health as opposed to professional competence of an individual, or to discuss the discipline or dismissal or complaints or charges brought against a public officer, employee, staff member, or individual. I think that's pretty clear. The exception there is professional competence. That must be discussed at an open meeting. We do have, however, times when you are considering the discipline or dismissal of an individual, and the reasons for the discipline or dismissal may be a professional competence issue. So if you have that combination, I'd like you to come and talk to Pat or I, and we'll help you through this, because it's not really clear where you've got the mixture of permissible and impermissible purposes for the executive session, although generally the rule is if there's a doubt, you go into open regular session. Now, if you're going to utilize the executive session for, say, discussing character, reputation, or dismissal or discipline, you must give that individual 48 hours notice, which must include the reasons for the executive session and the subject of discussion. That person has the right to say, I want the matter to be taken up at a regular session. And it's that person's call. If the individual wants it in public, it's public. Whether the body wants it in public or in executive session, it doesn't really matter. It's not their call. It's the individual's call. Also, the individual has a right to have counsel present with them in the executive session and at the public session. However, counsel's role is to advise the client, not to necessarily actively participate in the meeting. That is subject to the discretion of the chair of the meeting. Second reason for the executive session is to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. I think that's fairly straightforward. Third point is, and here's a little nuance to the law, to discuss strategy with respect to collective bargaining or litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body. Remember, I just told you that you can go into executive session to discuss strategy in preparation for negotiations with non-union personnel. But if you're going to discuss strategy with respect to collective bargaining, which means you're dealing with a labor union unit, you have to have a declaration by the chair at the beginning that the open meeting would have a detrimental effect on the bargaining or litigating position of the public body, and the chair must so declare in the motion to go into executive session. With respect to litigation, I think it's fairly clear if you have pending litigation, the chair will declare that going into or discussing pending litigation in open session may have a detrimental effect on the body's litigating position. But we have situations where the litigation isn't pending. It's threatened or it's potential. Let's use the word potential. The rule that the Attorney General is recommending that we use is that the litigation be clearly and imminently threatened. In other words, it's probably going to happen in a few days, and you're very certain it's going to happen, not just some generalized fear of litigation. You don't go into executive session because, well, if I say something in public, I might be sued. That's not enough. There has to be an actual imminent and clearly threatened litigation to utilize the executive session exception to the open meeting law. Yes, sir. Do you have a question? No. Okay. You may go into executive session to discuss the deployment of security personnel or devices or strategies with respect to security. I think that's it's pretty clear. To investigate charges of criminal misconduct or the filing of criminal complaints. Another frequently used executive session is to discuss the purchase, exchange, lease, or value of real property. This is if you are negotiating the purchase of land or perhaps preparing for an eminent domain taking. The chair, however, must declare that an open meeting would have a detrimental effect on the negotiating position of a public body. That's probably fairly easy to do because whenever you're considering buying or exchanging real property, you generally have a low price and a high price. Well, I won't accept less than this price, or I won't pay more than that price. And if the other side knew what that price was, well, that's where the negotiations would start. So I think it's probably fairly easy there for the chair to declare that an open meeting would have a detrimental effect on negotiating. Another area of executive session is to comply with any general or special law or federal grant and aid requirement. I'll give you a couple of examples. In the context of public housing, it's the identity of tenants in public housing is not a public record. So the law requires that any landlord-tenant dispute in public housing must be conducted in executive session. Also, if you're going into executive session to discuss a document that is not a public record, and for example, if you're going into executive session to discuss materials that are in somebody's personnel file, personnel file generally is exempt from the public records law, so that if you're going to be discussing it, that has to be an executive session to comply with the public records law. Another one with which we're somewhat familiar is to consider or interview applicants for employment or appointment by a preliminary screening committee if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants. This exception, however, does not apply to interviews of applicants who have passed a preliminary screening process. Again, the chair has to make the declaration at the declarative announcement before you go into executive session. The open session will have a detrimental effect on the public body's ability to attract qualified applicants. And if you have a preliminary screening committee, you cannot have more than a quorum of the members of the public body or the parent body on the preliminary screening committee. Mediation. We find that mediation is very valuable to help solve disputes in the public sector. Mediation itself is conducted out of public view. That's by statute. However, a public body that wishes to participate in mediation must make its decision to participate in mediation at an open session. And once the mediation has concluded, if there is a decision that is agreed upon, it must be announced in the open session. But anything that happens in the mediation session, of course, is subject to confidentiality and cannot be revealed later on. So it's the mediation itself which is in executive session, but not the decision to participate in mediation and not the agreement that comes out of it. And one point I want to make, I've received this question a number of times. Let's say you have a 5-member board, they vote to go into executive session by a vote of 3-2. You only need a majority vote to go into executive session. The 2 members of the body who vote not to go into executive session may participate in the executive session. I know some boards over the years have felt that if I voted not to go into executive session, I had to leave the room. That's not true. The majority of the board votes to go into executive session. The decision to go into executive session applies to the whole board. All right? So Pat's going to talk about minutes and records and a couple of enforcement orders, and we'll keep going.
Actually, the next thing that I'm going to speak on is that the open meeting law as revised gave the authority to the Attorney General to promulgate rules and regulations, and included in that regulation power was the right to authorize remote participation by members of public bodies. And within the last, I think it was the last month and a half, that regulation was promulgated by the Attorney General, and it is found in the CMRs, which are at 940 CMR. It's actually 29.10. The preamble to the regulation regarding the remote participation indicates that there are certain procedures and restrictions that apply, and it tracks some of the limitations that were included in the open meeting law itself, but it also encourages bodies to have members present whenever possible, but that the purpose for allowing the remote participation is to encourage as much involvement by membership as possible while promoting transparency with regard to deliberations and decision-making. In order for a municipality, a public body to utilize the remote participation, the municipality has to adopt the regulations, and in a town it would be the Board of Selectmen by majority vote could adopt remote participation as an option for public bodies in the town of Falmouth. If that vote is taken, the authorization will apply to all subsequent meetings of all local bodies within the municipality. There are some minimum requirements for remote participation, and these are coming from the statute itself. And it states that members of a public body who participate remotely and all persons present at the meeting location shall be clearly audible to each other. And the quorum of the parent body has to be present, as well as the chair, and if not the chair, a person designated to act in lieu of the chair shall be present at the location. Members who are participating remotely may vote. However, for remote participation, there are only 5 reasons upon which that remote participation is allowed, and it has to be based on a determination of the chair of the public body that the member's physical attendance is unreasonably difficult for one of 5 reasons. One is personal illness, the other is personal disability, the third is an emergency, fourth is military service, and the fifth is geographic distance. If the member who is participating remotely needs an accommodation, that accommodation has to be provided, and whether that be video relay service or other form of adaptive telecommunication. If an individual has a right to participate remotely, those accommodations have to be provided. The technology that has to be used in the remote participation can be telephone, internet, or satellite-enabled audio or video conferencing, or any other technology that enables the remote participant and all persons present at the meeting location to be clearly audible to one another. If video technology is used, however, all parties need to be able to see each other. And the public body that is utilizing the remote technology shall make the determination of what technology shall be used by that public body. The costs associated with allowing remote participation shall be determined by the Board of Selectmen, and it shall be funded through the Board of Selectmen. The procedures that need to be followed prior to any remote participation is that a member of the body who wishes to participate remotely has to reasonably notify the chairman in advance that they're going to have difficulty and why they're not going to be able to attend. At the start of the meeting, the chair shall announce the name of that person and the reasons for the remote participation that are consistent with the 5 earlier reasons I mentioned earlier. And this information has to be recorded in the minutes. All votes taken in which there is remote participation must be by roll call vote. A member who is participating remotely may also participate in an executive session. And when feasible, the chair shall distribute all materials that they anticipate being utilized at that public meeting to the individual who's participating remotely. Yes?
This is all triggered by a vote of the board to authorize this.
The Board of Selectmen, yes, yes. And if it is triggered, it applies to all boards, all meetings. Under the public meeting law, the public is permitted to attend all the public bodies when they are gathered to discuss public business, except for those executive sessions that are called for one of the valid purposes that Frank just reviewed. Any member of the public also has the right to video record or audio record a public meeting. However, they must first notify the chair of their intent to do so, and the chair can identify reasonable limitations on the activities involved in the recording so that they are not disruptive to the meeting. Prior to the beginning of such a public meeting, if there is a party recording the meeting, the chair needs to also notify the public in attendance. When the public attend an open meeting versus a hearing, they cannot address the public body unless authorized to do so. I mean, I should be clearer on this. All open meetings allow for public participation at the discretion of the chair. If it's a public hearing, there is a right for the members in attendance to speak on matters related to the hearing. If it's an open meeting that is not a quasi-judicial board, the chair of that open meeting is not required to allow public participation, but may. And if participation in either a hearing or an open meeting, all hearings are open meetings, I should be clearer in that. But if a person is disruptive, the chair has the right to tell them to stop their activities, and if they continue to be disruptive, the chair can ask for them to be removed. All public meetings, whether they be open meetings or executive sessions, require minutes to be taken. The minutes of all meetings must include the date, time, and place of the meeting, the name of the public body's members who are present and who are absent, a summary of the discussion of each subject, a list of the documents and exhibits used at the meeting, decisions made and actions taken at each meeting, including the record of all votes by the public body. This does not have to be a transcript, but those are the minimal requirements. Votes in executive session must be recorded as a roll call vote, as Frank noted. There are no secret ballot votes permitted in open session, and determinations on the disclosure or continued non-disclosure of executive session meeting minutes must be included in the minutes of the meeting at which that was determined. And just to step back for a minute, if executive session minutes are no longer, if it's no longer necessary to keep them private, the reason for which going into executive session has now passed, the litigation is concluded, for example, the public body needs to review on a routine basis the executive session minutes to determine whether or not the reason for excluding them from public records continues to exist. That review can either be done by the public body itself, and that should be an executive session, otherwise it becomes a public record. So in executive session, the public body can review those executive minutes, or there can be an individual, the chair, or another person designated to routinely review them and make a recommendation to the committee or the board involved. But that determination to release executive session minutes or not release after a review needs to be put in the minutes of the next meeting. Yes?
To review and accept executive session minutes, that needs to occur in executive session?
If the public body is doing it, yes, because if that document is distributed in open session, it becomes an open record, except for some very limited exceptions that I'll be reviewing in a minute.
So every time they have an executive session and they have minutes and the public body is to review and accept those, that needs to also be in executive?
Yes, yes. Yes?
Is it allowable to poll the membership without taking a vote?
I don't know of any law, ruling, or advisory opinion on that. As a general matter, I don't think it's advisable. Do you know of anything on point, Frank?
I don't know of anything on point about that particular question. But you could, as Pat has announced, have one member of the board, for example, review the minutes of an executive session and just make a report to the board.
I didn't realize you were dovetailing that with the review of executive session minutes. Is that what your question is?
No,
Okay.
you skipped over something. Is a member entitled to poll the membership of the board to be able to get a sense without calling a vote? Or is a vote required?
On any matter before them to do a straw?
That's correct.
Yeah. Again, I don't know any legal authority on point.
I believe it's probably okay, though, because everybody, when there's a poll, everybody reserves the right to change their mind.
And it's being done in the open.
Yeah.
It's not being done over the telephone, one
Right.
by one.
Right.
Right.
At a meeting.
Right. Yes.
Can I ask one thing about the executive session minutes?
Sure.
You said, I understand we have to vote executive session minutes in executive session, but to release them, you said that vote has to take place in open session?
No, the vote is in executive session, but the final determination, whether it be to retain them in privacy or to release them, needs to be recorded at that meeting.
At the executive session?
Yes.
Okay.
Did you indicate that something other than the multi-member body can accept the minutes of
Yes.
executive session?
Yes.
Who might that
The
be?
chair can review them, and another person designated to do so can review them.
To accept the minutes of the recording?
Right.
Okay.
Getting back to the, excuse me. The public records that are generated from open and executive sessions. We touched on that just briefly a minute ago. In an open session, the open meeting law includes a provision pertaining to the public records law. And it says that all the documents that are reviewed, such as minutes, notes, recordings, exhibits, become public records if they're reviewed by the public body in open session. There's only two exceptions to the document public record and open session rule, and they relate to personnel materials, and Frank touched on it in a brief way in his earlier discussion. The first is materials used in a performance evaluation, unless those materials were generated by the public body. But all of the materials received by the public body in open session regarding performance evaluation is exempt from disclosure as a public record. And then materials used in deliberation about employment or appointment of individuals, including applications and supporting materials, but not resumes. Resumes are called out as not an exception from the public record, a requirement. And going back to what we discussed earlier in terms of executive session, as soon as the lawful purpose for which going into executive session is no longer effective, all the minutes, notes, recordings, or other materials used in executive session become public records unless one or two exception applies. And now in this instance, the public record law is an opportunity to be utilized when you're coming out of executive session. And the list of exceptions from public record is found in Chapter 4, Section 7. It's a long list, and you don't want to hear it from me, but you should call Town Council's office. I would think if you have a question about materials that might be exempt under public record law that was reviewed in executive session, you don't let everything out like you would in an open session record keeping. And the second one is the attorney-client privilege. There are matters oftentimes in executive session that would have the benefit of an attorney-client privilege and should not be released. Since the recent amendment in 2010 of the open meeting law, the Attorney General's Office, Division of Open Government, has been responsible for enforcing the open meeting law, as Frank said earlier. They have authority to take and investigate complaints, bring enforcement actions, and issue advisory opinions and regulations. If an individual in the public has a complaint about what they consider to be a violation of the open meeting law, they need to follow a very specific process under the new open meeting law. They need to fill out a complaint form that is found on the Attorney General's website, and they must file their complaint with the public body and another copy with the town clerk within 30 days of the date of the perceived violation or the date the complainant could reasonably have known of the violation. Once the public body receives the complaint, they have 14 business days to review it and to take remedial action if they think appropriate, and to notify the complaining party of the remedial action. and to forward then a copy of the complaint and the description of the remedial action to the Attorney General's office. The process doesn't go any further at that point unless the party complaining is not satisfied with the public body's response. They then have 30 days after they file their complaint with the public body, up to 90, between 30 and 90 days of that date, to file their materials with the Attorney General's office and ask for their review and determination as to whether or not there has, one, been a violation, and two, whether the public body responded appropriately. I think that brings me to the end of...
Well, thanks for coming. You can tell your friends and colleagues that we're going to do this again in the evening, sometime in January, for those members of boards and committees who have otherwise engaged during the course of the day. So I want to thank you for coming. This is a very important subject, and I'm glad you all could come here and participate with us in this. And, thank you. Do we have a question in the back? One question.
Your question, right?
Yeah, because I went on and they're not
Does the town have a person skilled in sign language to help
Yes.
that person?
Yes, we do.
Thanks, Frank. Pat?
Thank you.